Good afternoon, everyone that's joining us this afternoon. We'll start the webinar shortly when a few more people have joined. Okay, there's a few more people joining. Just give it a couple more minutes. Okay, it's just gone 4 o'clock. I think I'm going to kick off now. We've got about 23 participants. So first of all, I'd like to say thank you very much to Mace for inviting Spencer West to come and talk to everyone this afternoon regarding insolvency, and in particular subcontractor insolvency, and how you can reduce the impact of subcontractor insolvency on your projects. So this is a real issue facing the construction industry today. When we were originally due to do this presentation in March, I'd seen in the construction news earlier that month that there'd been 58 construction administrations in 2020, and more than 400 companies were involved in stages of liquidation since the start of this year. There was a 56% monthly rise in the number of firms affected between January and February. Well, COVID then hit. In fact, it was the week we were due to come into Mace and actually do the training. It was that week that Boris made his announcement, and no one could have foreseen that was happening. I regularly recall reading the construction press and seeing headlines of some quite major construction firms going insolvent. However, following the introduction of the Corporate Insolvency and Governance Act 2020 in June this year, which we will look at today in our training, and which had a retrospective effect back to the 1st of March 2020, this appeared to alleviate the problem somewhat. But the reality is, we all know that this year has had a dramatic impact on the UK economy and everything that's happened with COVID. And if the temporary measures which the government put in place in June under the Corporate Insolvency and Governance Act 2020 are lifted, which is quite possible, the headlines are likely to be a regular occurrence over the coming months. I would like to say that our seminar today is not intended to be a technical seminar on insolvency practices and procedures. Rather, we'll consider what insolvency actually means and what a main contractor chat facility. So do please send us questions whilst we're carrying out the training, and we will try and answer them as we go along. We'll also try to keep this seminar to around 45 minutes to give you the opportunity to ask further questions at the end. So first of all, what I'd like to do is introduce you to my other two presenters who are here today. So I myself, I'm just in Brazil. I'm a partner in the construction and engineering team at Spencer West, and I've been a construction practitioner for around 20 years. Including time in-house and including some time actually in the Mace legal team, so I may well have met some of you and even worked with some of you previously. I've also got Elizabeth Bago, who is a fellow partner of mine in the construction and engineering team, and she specialises in infrastructure projects and renewable energy. And last but by no means least, Nigel Croxford, who is a consultant within our team and specialises in construction and engineering, dispute resolution and health and safety. Now, we're just 3 members of a much wider team, and I just wanted to introduce you, although they're not here speaking with us today, the rest of our team back at Spencer, who is a
and then they've introduced temporary changes. I'll talk about the permanent changes briefly, first of all. So the permanent changes that the Act has introduced, first of all, you've got a moratorium, and that is really, again, aimed at trying to rescue businesses in financial difficulty, and it gives them a breathing space. It's a bit like a payment holiday. And the directors still remain in control of the company, but you have a monitor that really oversees that. And the monitor will be an insolvency practitioner. There are restrictions on what directors and the company can do. The moratorium is initially for 20 business days. So you can see it's pretty quick and short. However, it can be extended. It can be extended by another 20 business days or even up to a year. But it's really for a company to try and work out how it might rescue itself. So the other thing about a moratorium is, although it's a payment holiday, the monitor will still be paid, and rents will also be paid. The other permanent change, which is relevant to you guys at Mace, is the ban on termination provisions, and I'll talk about that a little bit more when we look at the slide on the contractual framework under the JCT and NEC. But just as an introduction to this, there's been, where you've got a supplier of goods or services, it is not allowed to terminate a contract for insolvency or do any other thing as a result of a company's insolvency. There are exceptions to that, and I'll talk about that a little bit more further on. But just to sort of, that does have an impact clearly on construction-related contracts and facilities management contracts. The other permanent change that's pretty key, and this is new, is the restructuring plan. And this has been introduced. It basically allows a company to inject rescue finance. And the other important thing about the restructuring plan is it can get dissenting creditors. It binds dissenting creditors. The court will actually intervene here, but it binds dissenting creditors so that, provided that there are conditions met. One of those conditions is that the creditors wouldn't be prejudiced. They're not any worse off than had the company initiated any other insolvency procedure, and you have to have at least 75% by value of class of creditor or members that have a genuine economic interest, that if the relevant alternative were pursued, voted in favour of the plan. So those two conditions need to be satisfied. So it is important, and it is key. And again, it does enable debts to be restructured. So those are the three main key permanent changes. There are also some temporary changes that have been introduced, again, to deal with the COVID-19 situation. The first one, and I won't spend very long on this because this now has expired on the 30th of September, but it was the suspension of wrongful trading. So if you're a director of a company, you've got to act in the best interest of the company, and you can't carry on trading if you know that the company is in financial distress. So that was suspended. So the directors and the company could carry on. However, now that has been lifted, I wonder to what extent directors are now finding themselves that they've come unstuck with this. I mean, they would have had to have carried on operating the company in a prudent way. But just to say that was introduced again as to give companies a breathing space while they worked out what to do. But that has expired now on the 30th of September. So there is no longer that respite for directors who are sort of running a company that is under financial distress that has been caused by COVID-19. And then the other temporary measure, which has been extended until the 31st of December, is a moratorium on serving statutory demands and winding up petitions. So again, linked to COVID-19, not allowed to serve a statutory demand or a winding up petition if the company has got itself into trouble or financial difficulties through COVID-19. If you want to go ahead and serve statutory demands or a winding up petition, you have to show reasonable grounds and show that you believe that the financial difficulties are not linked to the COVID-19 situation. That's a bit of a quick sort of canter through the changes. If there aren't any questions, I will go on to the next slides. Please say if it's, I'm going too fast, by the way, guys. Just say something in the chat if it's a bit too quick. Otherwise, I'll move on. So looking at the standard form construction contracts, we've just chosen JCT and NEC, which are probably the most common ones or the ones that you come across the most. So clearly in each of, if you look at JCT initially, JCT actually sets out what it considers as insolvency. So in clause 8.1, it will list out, and it refers effectively to the insolvency procedures. It lists out the insolvency procedures. For example, it will say when a company enters into administration within the meaning of, and it will refer to the Insolvency Act, or it will talk about a voluntary winding up or a making of a winding up order. So already it's giving you the parameters of what it considers insolvency is. And under the JCT, there is a right for both the employer and the contractor to terminate for insolvency. And of course, the ramifications of, for example, the contractor becoming insolvent under the JCT is that it doesn't get paid any longer. It has to rectify defects. It's a serious position for the contractor to be in. And it won't get paid anything until it has rectified defects and presented a final account. The same or a similar position applies under the NEC 4. So again, you've got a clause in the contract that actually sets out what is meant by insolvency. And again, it refers to the insolvency procedures. So for example, it mentions that a company might have had, or a contractor has had, an administration order made against it, or a winding up order, or a provisional liquidator appointed. So these are the things that constitute insolvency. And again, similar rights apply, although under the NEC 4, it's not quite as draconian as the JCT. That the contractor still has a right to be paid, but it still has to effectively assign the benefits of contracts or remove plant and materials and present a final amount to be assessed for payment. So that's broadly the position under those contracts, and they often will lead to automatic termination. I think, Justine, we can move on to the next slide. That's okay. So key here is the effect of the Corporate Insolvency and Governance Act. And again, this is key to take away in this context. So referring back to the permanent change that's been made, which is that suppliers of goods or services cannot terminate for employer insolvency. And I think the key thing here for people to remember is that this just impacts the supplier. It does not impact the employer. So a supplier, so for example, if a supplier of goods and services becomes insolvent, so for example, a subcontractor or a contractor who's in contract with an employer, if they become insolvent, the employer still has the right to terminate the contract. However, if the employer becomes insolvent, then the contractor does not have the right to terminate the contract if it's related to a relevant insolvency procedure. It's really key, this, because it's a big change. There are exceptions, which I'll mention in a minute, but it's key to understand that the right will still exist for the employer, but not the contractor. And the same applies down the chain of contracts. So a subcontractor will not be able to terminate for a contractor's insolvency, but a contractor can terminate for a subcontractor's insolvency. And as you can imagine, this can be quite onerous for a supplier. So there are exceptions, and one of the exceptions is, of course, if the employer's liquidator agrees to it, or the court agrees to the supplier or contractor terminating the contract for insolvency, or it causes the supplier stroke contractor hardship. So, because clearly, if it's not allowed to terminate the contract for insolvency, it's still obliged to be providing services to an employer who hasn't got the wherewithal to pay. Now, it doesn't apply necessarily to ongoing payments, but it will stop the contractor from trying to claim back payments. But clearly, if the employer is in financial distress, the likelihood of it getting paid at all is pretty slim. So that is a key change that's been introduced, and there'll be a lot of consequences as a result of this. The chances are, and maybe some of you have come across this already, but you'll probably find that suppliers stroke contractors will look to adjudicate at an earlier point in time if there is non-payment from an employer, or they'll look for other ways to get out of the contract prior to the insolvency coming down the track. So I think that it'll be interesting to see what happens with that. I think that's probably all I'm going to say on that for now, Justine. I'm conscious of time. So I guess just very quickly on the next couple of slides, clearly if you have got contractor or subcontractor insolvency, the project issues are pretty serious. And as you can see on this slide, we've listed a few. Clearly, you've got unfinished work. There are program implications. You'll have delay to completion. And key, of course, is of course if there is a provision in the contract that allows the employer to claim liquidated damages. If you've got a contractor who is in financial difficulties, it's unlikely to be able to pay those liquidated damages. There'll be a lot of wasted time spent having to deal with the issue, and then also finding and procuring a replacement subcontractor, which is not easy, particularly getting contractors to take on other contractors' designs. So it's pretty problematic, to say the least. And then I think finally for me, other project issues, of course, and Nigel and Justine will come on and talk about this in a bit more detail. You may find you've got worthless parent company guarantees or worthless warranties. The cost implications of dealing with all of this will be, there'll be a lot of cost in dealing with this. And of course, it goes without saying there's limited recourse in the event of a dispute with an insolvent subcontractor. So I think I'll just stop there, and Nigel and Justine will talk about what we could do to prevent this happening in the first place. So thank you, guys.
Right. Well, I'm Nigel Croxford. Nice to meet you all this afternoon. So I come from you've heard the legal position and the contractual position, but I come from a practical background. I've spent many years as a project manager and construction director, and so I have actually faced issues of insolvency with subcontractors and contractors that have been employed by my company. So I'm going to give you the benefit of, if you like, my experience and what I've done in the past to try and deal with that. So yeah, really, the ultimate aim is to try do whatever you can to avoid employing a contractor that may become insolvent. And of course, none of us have got a crystal ball. You can only do your best on that, but there are things you can do. So the primary aim is to gather evidence and then evaluate the risk based on that evidence. And my starting point would always be to use a credit reference tool such as Dun & Bradstreet or Experian to check on a supplier's credit status and see what their trend in performance is. But we have to be mindful when doing that most of those reports are quite well out of date. They're based on accounts which could be up to a year out of date, but you do get feedback coming from suppliers, if you like, to the contractors who actually report back on payment performance. Also, you know, if there's a CCJ that's been issued, or the company is taking out the debentures or loans, that kind of thing would also go on there, and that will actually affect their credit rating. And the other thing I should say, sorry, in dealing with this, because we're talking about subcontractors, subcontractors can be of many different sizes. So, you know, it could be a very large subcontractor that's a very important part of the project with design, or it could be a smaller subcontractor. So the things I'm going to say now is, if you like, the ultimate, but it depends on what your subcontractor is doing. You know, you may want to temper this as you go through. So looking at the credit reports, I'd also look at the directors and try and find a bit more out about the company. It may be that you already know about the company, but the more you find out about them, the better it is, because you might find that the directors who are actually running that company may not have a great track record of company success, and they may have quite a number of business failures behind them, and that will all be on the record. If you like delve in through an Experian report, you will actually see the companies that they've been directors of, and whether those companies are still existing, or whether they've ceased to trade, and whether that's an adverse cease of trade. So that's very useful. Because accounts can be well out of date, statutory accounts, ask to see management accounts, because if you get those, you're going to get hopefully a more up-to-date picture, and be mindful of the fact that, you know, you're going to place an order on the basis of what you see, the information they give to you. So they need to make sure that information is not misleading to you in any way. And obviously, as we all know, cash is king in contracting. So how are they funded? You know, do they have they got very much money in the bank account? You know, do they have their own cash reserves for their trading activity, or are they reliant on payments coming in? Do they need to hold on to cash? Are they in arrears with their cash flows? And are they dependent on loans and overdrafts? And if they have an overdraft, what size is it, and how much headroom do they currently have? I mean, these are, if you like, uncomfortable questions for subcontractors to answer, but nevertheless, they are important questions, and you know, and they should respect the fact that, you know, you need to go through a proper due diligence and make sure that you're safe in appointing them. So I wouldn't be afraid to ask those questions, and look at their turnover, their past turnover, and the size of current projects. Are they actually outstretching themselves? You know, is this project that they're doing larger than they've ever done before, and is their current turnover significantly higher than they've done historically? So just see if they are actually growing too quickly and overstretching themselves, and possibly they don't have the resilience to deal with the cash flows of larger and more projects. And is your project a significant percentage of their annual turnover? You know, how important is it to them, and how, you know, if they've dealt with smaller turnovers in the past and can deal with those cash flows, suddenly they're faced with the delay in payments from starting to getting their first valuation on a much bigger project. What effect will that have on them? So these are all good questions to ask. And what work do they currently have on site? What are they projecting to have? Are they being too ambitious? So I'm asking all these questions looking at their past performance. I want to see if, you know, if they've been successful in the past and they've traded well, is the situation changing now? Is it likely that, is it possible that they're actually being too ambitious and potentially putting themselves under strain? And I think also, if they are growing fast, do they have the resources to manage the increased growth of the company? And by that I mean the technical and managerial skills to actually properly manage their work and do the work properly. So that's an important question. So I'm on to the next slide now, please. And I would talk to previous clients, people they've worked for before, find out, you know, how their projects went, what issues did they have, how did they overcome them? You know, how did the client overcome them? How did the subcontractor overcome them? Get feedback from any supply chain employed by the subcontractor. So if it's a large M&E subcontractor, he will have in turn his own subcontractors as well, and talk to them if you can and get feedback from them. So find out whatever you can from whatever source you can, even on social media, but be mindful that, you know, when you read things on social media and the press, that kind of thing, you know, you have to be careful that it's factually correct. And if we can just move to the next slide. And if there's a parent company, my advice would always be insist on getting a parent company guarantee. I have found that contractors don't like to give a parent company guarantee and a bond, but I would see if I could get both. Obviously, as I said earlier, it depends on what the subcontract is for, you know, the size of it. But if it's applicable, then I would want to get both. Companies, you know, I've seen in the past, it's happened to me, I've seen companies restructure and have disposals, and it's a very easy way to shed ongoing liabilities, and we need to be absolutely careful that we've got protection for a period right up to the end of the limitation period for latent defects. So yeah, try and get both. And, you know, as I say, ask for a bond. You know, the cost, one of the good things about bonds is that when they go to the bondsman would also do financial checks on them. And they may want a counter indemnity on the bonds. So that's a good test of their financial position. And the cost of the bond is also a very good indicator. So, you know, they come to you and with I mean, in my experience, contractors generally get around a bond cost of around 3% of the bond amount per annum. But if they come to you and the bond percentage cost is higher than that, for me, that would actually send warning bells to me. And if they come back to you and say, look, we can't get a bond, and sometimes companies can't because there's a limit, you know, bonds, there's a limit to how much you can get as a company on bonds. But you know, if they are struggling to get a bond, I think that for me, that would make me want to be very, very careful in employing them. So that's the end of my slide there. Over to you, Justine.
Yeah, thanks, Nigel. Just before I talk about the things that we can put into the contract, we've had a question on the chat. And I think this one's for you, Liz, if you're able to answer.
Yep.
I'll just read it out to you. So going back to the CIG Act changes, what are the exceptions to the ban on termination? If it was a large contract and only 50% has been paid and the employer becomes insolvent, surely the main contractor can't be expected to complete the work.
Yeah, no, it's a good question. And as I mentioned, there are exceptions, of course, to that sort of ban on termination. And basically, if you've got the employer, that we'll talk about the employer who's actually, and this only applies when the employer has actually gone into one of the insolvency procedures. So, or related to the employer's insolvency. If the employer or the employer's liquidator or administrator agrees to the termination, and I mean, I guess depending on the conversations you have with them, then you can, if they consent to it, you can terminate. The other thing as well is if the court is satisfied that that particular subcontractor would suffer hardship, then of course there would be a right to terminate in that instance as well. I think what will be interesting is to see what happens with that, because I agree, it sounds very draconian, and I'm not surprised that question's been asked. I mean, I think, and the question then becomes is, well, what does hardship mean? So I think the court has to be satisfied that if the supplier had to continue with the contract, that it would suffer hardship, but hardship's not defined. So I think in the coming months that might be tested. But it's a good question, and I'm not sure there's a completely coherent answer to it other than the one I've given you.
Okay, thanks, Liz. Matthew, thanks very much for the question. Do continue to ask questions, and if you want any more further clarification, then as I said, please use the chat box. Okay, so I'm now going to talk about what things you can do to put in your contracts, into your subcontracts, to put you, Mace, in a strong position in the event of actual or suspected insolvency of one of your subcontractors. So first of all, ensure that there is careful scrutiny of the contract sum analysis and cash flow schedules to ensure that they are not heavy at the front end and therefore risk insufficient monies left to finish the job if a subcontractor does become insolvent. So ensure that your stage or milestone payments are not front loaded, with the subcontractor receiving a greater proportion of the overall subcontract sum during the early part of the works. Also, include retention provisions in your subcontract, which can either be a percentage from each of the stage or monthly payments, or alternatively consider whether or not you want to use a retention bond. As I've said on this slide here, also ensure that under the contract, the subcontractor is obliged and must provide you with, first of all, full details of any subcontractors or suppliers it intends to contract with, particularly if this is a subcontractor with design responsibility and it's subcontracting any of that design down the supply chain. If it does have subcontractors that are undertaking any particular parts of the design, then ensure that the subcontractor is obliged to provide you with a collateral warranty from that subcontractor, and we'll come on to why that can be important a bit later on. As Nigel mentioned, get in place guarantees, so parent company guarantees, performance bonds, and also product warranties and any guarantees. So if the subcontractor is providing any particular equipment or kit or anything that you'd expect to get some sort of product warranty from and guarantees, ensure that you get those in place up front before the contract is finalised. Get full details and full disclosure from your subcontractor with regards to the PI insurance cover that it has in place, or alternatively the product liability insurance. Also take vesting certificates if the subcontractor has got any materials that it's keeping off site and isn't intending to bring them onto site until it actually needs to use them within the works. Again, look to take vesting certificates. Some further points that we would recommend that you include in your subcontract upfront before the subcontract is signed by the parties. Include in your subcontract a right to terminate immediately on an insolvency event occurring. As Liz has explained and as we've just spoken about, you can keep these provisions in your subcontract because the CIG Act doesn't apply when it's insolvency down the line. This is only really of concern when it's insolvency up the line. Ensure that your subcontract includes some early warning drafting, and my next slide I'm going to show an example of what that drafting could potentially look like, so that the subcontractor is contractually obliged to tell you and tell the contractor if it becomes aware of any matters that could adversely affect its ability to carry out the subcontract works or its performance. So I'll put up that drafting in a moment. As I mentioned above, make sure that there's retention provisions, particularly if you're not able to take a performance bond. Perhaps the subcontractor isn't able to procure a performance bond. In the current market, that can become quite a reality. Also, the subcontractor that you're dealing with might not have a parent company, so there's going to be no parent company guarantee available either. So in those circumstances, probably the only other piece of security that you can take is retention. If it is appointing any subcontractors and also has its own supply chain, then consider including within your subcontract a requirement that those subcontracts and supply agreements can be assigned over to you in the event of an insolvency. And these should include the balance of any retentions and any further sums due under any other such contracts. Also include a right of cross set-off any amounts due to the subcontractor. It may be that you are also using this particular subcontractor on other projects, not just this project, and that you have a number of different subcontracts in place with this subcontractor. If the subcontractor is going insolvent, cross-contract set-off may not be particularly helpful, but it's still something worth having in there as an added piece of protection. Oblige the subcontractor in your subcontract to provide a lien over any plant that it's providing, any machinery and any materials. And this should come into effect at the date of insolvency. Now, this may not be possible if plant and machinery that the subcontractor is using may be hired rather than owned. But in the position where it does own the plant and machinery, you want to be able to have a lien over it, and that will give you some extra security. A further suggestion is to include a requirement in the subcontract that in the event of insolvency, then you as main contractor are appointed as the subcontractor's attorney, and you're given authority to carry out acts and execute documents which might be necessary to render your rights effective within 7 days of a written request from the main contractor. This can be particularly useful with regards to things like collateral warranties, although a savvy subcontractor is very likely to push back on that, but it's something you may want to try for. As I said, I have got some drafting, which I've used on projects, and what this drafting does, if you have a read through, I'll just give you a moment or two to have a read through. What's quite useful with this is that it obliges the subcontractor to keep the main contractor abreast of its financial status throughout the state of the project, and if necessary, it's obliged to provide you with management accounts at any time that you ask for them, a formal letter from a statutory director or a member if it's an LLP confirming the solvency of the organisation, and potentially a bank reference letter. And if you request this information and the subcontractor doesn't provide it to you within 7 days, then you have the right to omit works, appoint others, and quite crucially terminate the employment of the subcontractor. So that gives you an additional right. If you're concerned that the subcontractor may well be heading in the direction of insolvency, this gives you an additional right of termination if it doesn't provide you with the information that is required as stated in this clause. I'm now going to hand back to Nigel, who's going to think about some practical steps that you can take whilst the project is running, whilst the subcontractor is still on site and carrying out works, just to be aware of in case of subcontractor insolvency. Nigel, you're on mute.
Sorry, hopefully you can hear me now. Yeah, thanks very much, Justine. Yeah, so really we just need to look out for the warning signs, and they can come from all different directions. So you can get rumours on the site. You can look out for official announcements. If the company's a PLC on stock market, you will see announcements going out on that. you might see that there's the subcontractors in delay, or start to get in delay on site. There seems to be no apparent reason. It may be just lack of labour or lack of materials. It may well be it hasn't got the cash to pay its supply chain, and that's causing it to get into delay. So look out for that. Try to foster a sort of an open approach to subcontractors on site, because if you know if they feel they can talk to you, they might tell you things that maybe you know they think you might need to know. And if you've done checks on Dun & Bradstreet or Experian, subscribe to the regular updates, and then if anything changes, you know, you'll get to hear about that as soon as it happens. And are there any personnel changes going on that you can't understand, or any redundancies? Are they cutting? Do they seem to be cutting their overhead? So those typically those are the things that I would be looking out for. You know, if the subcontractor has got preliminary costs in their contract sum build up, and they are in culpable delay, then you know, make sure you're never in a position where, you know, if they do become insolvent, you don't have sufficient prelims to finish the job. So make sure you make suitable adjustments to the payment of their preliminaries as the contract works proceed. So that's it really. Over to you, Justine.
I think, oh yes, sorry.
We have some questions as well, I've noticed.
Yes, shall we deal with those now or at the end? Let's all have a look at that. Yeah, Liz and Nigel, if you'd be having a look at those, I'll continue, and we'll perhaps pick those questions up at the end. So first of all, if there are any warning signs of an imminent insolvency, consider whether it would be appropriate to instigate an adjudication to sort any disputes out at this time. This is particularly key now in light of the inability to terminate a contract for employer insolvency. Adjudications can be a powerful tool to maximise cash recovery in an imminent insolvency situations. Obviously, as I'm sure many of you are aware, disputes are resolved quickly, usually fairly quickly, and the contractor, should it be required to pay sums to the employer, or rather the subcontractor, should it be required to pay sums to the contractor, will have little recourse to overturn the decision of an adjudicator other than having to go to court, which is obviously costly and certainly does put people off. The short timescales of an adjudication process mitigate against a very detailed and forensic review of the underlying claims if they're substantial. However, it's obviously crucial that the action is taken at the right time, as an adjudicator is obviously of little use once an insolvency practitioner has been appointed. Also, obviously require the subcontractor to comply with the contract requirements regarding provisions of financial information and accounts. As I said, sorry about that. As I recommended earlier, if you include the drafting, the suggested drafting, and you can rely on that when the contract is up and running, then you can oblige the subcontractor to provide you with that information whilst they're on site carrying out the works, which can be a powerful tool for you. Also ensure that it complies with the contract requirements with regards to provision of any subcontracts that it's entered into, supply contracts, collateral warranties, and also any information of any off-site materials, and providing you with vesting certificates, etc. One note actually, just to say, we intend to send a recording of this and our slides round over to Mace when we've completed the webinar today. So you will have a copy of the contract drafting that I referred to earlier. So what if you do suspect that the subcontractor has in fact gone, well, if you find out that the subcontractor has in fact gone insolvent? So firstly, it's important to act quickly and very proactively. It's imperative that the contractor actually checks that the subcontractor has in fact gone insolvent. If it hasn't actually gone insolvent and the contractor doesn't correctly follow the termination route, then it could find itself in in repudiatory breach of contract for wrongful termination and end up itself in some sort of adjudication or claim. So it's very important to ensure that the subcontractor has in fact gone insolvent. If insolvency isn't listed as a ground for termination under the contract, there may be other options for termination. For example, under clause 7.4 of the JCT Standard Building Subcontract with Subcontractors Design 2016, the contractor can terminate where a subcontractor fails to carry out the works regularly and diligently, which would almost certainly be the case if the subcontractor is insolvent or is about to enter insolvency. As I mentioned, if you include the suggested drafting that I provided, then you may well already have that right to terminate if the right information hasn't been provided. You need to ensure that proper records of losses arising out of the insolvency are maintained, and also, sorry, excuse me. It's recommended that the contractor should start engaging with the relevant insolvency practitioner, and in conjunction with this, as I said, ensure that the contractor has got, that you've got proper records and evidence of all the losses arising as a result of the subcontractor's insolvency, and ensure that they're maintained and preserved. You also may have a claim against the subcontractor's PI insurers, and this is under the Third Parties Rights Against Insurers Act 2010, if any defective works are discovered, if the subcontractor has gone insolvent. So what other practical steps should you be taking if you just find out that the subcontractor is insolvent? Well, first of all, it's really important that you get copies of all relevant subcontract documents and all documents relating to the subcontract, including all payment applications and notices served to date, copies of any subcontracts if you hadn't already got copies of them during the course of the when the work's been carried out, insurance policies if you don't already have them, any vesting certificates. If the subcontractor has design responsibility, ensure that you are furnished with up-to-date copies of all drawings and also any copyright licenses that are in place in relation to materials. Make sure that the site is secured. There may be subcontractors further down the supply chain that have not been paid and want to come onto site and remove materials and equipment from site. Consider whether it's necessary to engage a replacement subcontractor to complete the works, and if so, act quickly to avoid the contract works getting into delay. You don't want to be in a position where the subcontractor's insolvency has caused you delay vis-a-vis the main works that are being carried out on site, which could put you at risk of liquidated damages from the employer. Also, record the condition of the site and have a site report prepared showing the state of the works, ideally by an independent professional, i.e. those works that the subcontractor has carried out. Include the value of the completed works executed to date, including any variations, all goods and materials on site, and obviously a record of any defective works will be important, particularly if the contractor does intend to engage a replacement subcontractor, because you want to ensure there aren't going to be any disputes with the new subcontractor regarding the existing condition of the site when they come onto site. Consider whether there are any goods or materials that are located off-site which have been paid for, and obviously identify those and try and get hold of them. Most construction contracts provide for payments to the subcontractor to stop upon its insolvency, but obviously be mindful of the requirements of the contract and to serve pay less notices if necessary. The contractor will need to keep a full account of all the payments being made to the subcontractor to date, and then a detailed account of the costs of completing the works, as a final account will obviously need to be prepared. If you have been able to take bonds or parent company guarantees, and those are in place, if there's a parent company guarantee, does that cover the current situation? If so, notify the guarantor, i.e. the parent company, that the security is going to be enforced. However, it's highly likely if a subcontractor with a parent company has gone into insolvency, it's likely that its parent company is likely to be in a similar situation, and therefore the parent company guarantee may be of little value. If there is a performance bond in place, consider carefully whether or not you're in a position to make a call under the bond in the event of subcontractor insolvency. And if so, then you need to comply with the requirements of that bond to make the call. There might be an advance payment bond. If so, if the contractor has made an advance payment to the subcontractor, for example, for where materials the subcontractor might have had to secure with a long lead-in time, then the contractor may have provided an advance payment bond, which could provide recourse in the event of subcontractor insolvency. And then finally, what about collateral warranties and any step-in rights? If you do have collateral warranties, ensure that you do have copies of them, check what they say and see whether or not they have step-in rights in favour of the contractor. If there are step-in rights, then the contractor will hopefully have an option to step into the subcontractor's place with regards to any subcontracts and employ the subcontractors directly to complete the works. And this then may mean that you will not need to employ a new subcontractor to carry out the works if you can just step into the shoes of the subcontractor and employ the subcontractors. Ensure that if you cannot step in, if you can't step in, then you could seek to enter into new direct contracts with the subcontractors, but you must take care if you propose to make any direct payments to subcontractors outside the exercise of any step-in rights, that these don't fall foul of the insolvency rules. Otherwise, you could find yourselves having to make payment twice, first to the subcontractor, but also to the subcontractor if it's found that payment should be made to the subcontractor in the first place. So there's some of the suggestions and practical steps that you can take if the subcontractor has unfortunately gone into insolvency. Okay, I can see that we do have a number of questions. I know we had a few questions previously. Nigel and Liz, are you able to take either of the questions with regards to the project bank account? Either of you looked at that?
Do you want to take on this?
You take that one, Nigel. I can take the other one about the Construction Act, and I'll say something as well about the previous question Matthew asked.
Oh, okay. I thought you were going to answer that one, so I didn't prepare for it. Sorry. Do the second one first, then. Yeah.
So Matthew, and sorry, Matthew. Before I answer that question, just coming back to your question about the payment for the contractors and subcontractors. I think probably what you can see from some of these slides here is that I guess subcontractors and suppliers will be putting things into their contracts, or maybe doing better due diligence on the employers' solvency status, etc., because they know now that there will be this, they won't be able to terminate in the same way. So I think you'll find going forward that contractors will start putting things in the contract, or they'll be wanting warning signals to be given prior to the point at which an employer becomes insolvent. But I'll answer your question on, does the Construction Act prevent payment being withheld by performance? No, it doesn't specifically exclude it. Generally, if you want to, and I know this is done with cross-contract set-off on projects, but actually it's if you want to do that, you've got to specifically set that out in the drafting of your set-off clause in the contract itself. I don't think, and also the Construction Act, I think it's section 110 A of the Housing Grants Construction Regeneration Act, which was introduced by the Local Democracy Act. It doesn't address that specifically. So although if you look at the drafting, you could be forgiven for thinking actually it does expressly exclude cross-contract set-off. So I think it just to sort of summarize, the answer is no, it doesn't expressly prevent it, but there is the guidance generally states that if you do want to have cross-contract set-off, you draft it in specifically into the contract, because it's unclear. I don't know if that answers your question. Let me know if it doesn't.
Okay, and the question from Jim Crouch, and good afternoon, Jim. If there is a project bank account and a valuation is in place, when a subcontractor who is party to the project bank account notifies of insolvency, should the payment be completed? Is there a right for the insolvent subcontractor to be paid? Well, obviously it depends on the terms within the subcontract, but the usual rule is that when a contractor is insolvent under JCT at least, all payments are then suspended at that point, because you have to get the project finished. You keep that payment. It's the subcontractor is entitled at some point to be valued for his work, but you need sufficient money to get the job finished. So, and once you've got the job finished and you know what the net effect of the completion of his work is, then you can actually do the balance sheet exercise and work out the payment that is due to the subcontractor. I hope that answers your question, Jim.
And I agree with you, Nigel, on that. And you're absolutely right. Under the JCT, particularly, the contractor doesn't get paid until it's rectified defects and completed the works.
Yeah.
Great. Okay. Well, we've just run over very slightly, which I don't think is too bad. Once again, I'd really like to thank Mace and particularly Sam Bailey and Nikki for helping organise this. As Spencer West has a number of very experienced construction and engineering lawyers, and if you would like any training on any other particular matters or subject matters, then do please let us know or get in contact with Nikki, and she can let us know. As I said, I'm going to issue the slides and the recording to Nikki. It has all of our, as you'll see onto the last slide, it has all of our details. Do please feel free to contact any of us directly if there's any further questions you'd like answered from today's training. And it's been a pleasure to speak to you all this afternoon. Thank you very much.
Thank you.
Thank you.